Good morning. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, with labor attorney Jung Bong-soo, we will cover a story that was published by the Labor Daily, and the title is the resignation letter. The effect of the resignation letter. So, could you explain what the story is first?
Yeah. Okay. Hello. How are you today? This is Bong-soo Jung, Korean labor attorney. Today I'd like to talk about some resignation letter. So usually separation or termination of employment is very important. So Korean labor law strictly protecting workers from unfair termination. So in Korea, so employer habitually ask some particular employee, you conducted such a misbehavior, so you should submit your resignation letter as your voluntary act. So in this case, usually in Western culture they say, I fire you, that means I give you my opinion, so your employment is terminated. But in Korea, because the termination or dismissal is very strictly protected and restricted. So instead of firing you, they say you should submit your resignation letter. So, but it has same result. So resignation is the expression by the employee who want to resign. So that means he give up his all right in the employment. So when employee is terminated or fired or dismissed, then they can take a legal action. But if they submit the resignation letter, they cannot get any remedy claim. So regarding this case, there are two labor cases I want to show with you. One case is when employee retired and this company has usually most of workers served 3 more years until they get the 60-30 years. So this one employee, he retired, and then he has a 1-year contract. That then when he completes the 1-year contract, company provide some special dinner for him and also submit the resignation letter. Please sign here. This is some way, some document, so you can get new the employment, like new employment contract. So he, without thinking anything, he just signed. So then he could not get reinstatement. I mean, his contract was not renewed for another year. So he take some legal claim, remedy claim to the Labor Commission. There, his remedy claim was rejected because he submitted the resignation letter. So it was very sorry to hear that. So, but this is voluntary resignation. So second case is the employee who has served the company for 23 years. He has some argument with the general manager. So general manager said, in this situation we cannot hire you anymore, so you should submit resignation letter. Then company will give you maybe benefit for unemployment allowance. Also you will get 3 months additional salary. So employee rejected, but because of good benefit, he submit the resignation letter voluntarily. So, but some time later, company just terminated this employee, and company didn't pay 3 months additional salary, also severance pay. So this employee claimed to the labor office for unpaid wage for 3 months and severance pay. Then labor office said he's entitled to maybe severance pay, but 3 months additional salary is based on mutual agreement. So we could not find any evidence. So even though there is evidence, this is not wages, so you have to claim so civil court. So then after he received the severance pay, then he claimed the remedy to the labor commission. Then labor commission rejected his claim because of he submitted the resignation. So you submit resignation also when in the time of receiving some severance pay, you said to the labor inspector you resigned. So that means you submit the resignation letter. So that is that is evidence that you are not fired illegal, maybe unfairly. So we could not help you. So in this employee, she could not receive unemployment benefit. Also, she could not receive 3 months additional salary because it was a verbal promise, a verbal agreement. So there are no evidence. So I think this employee complained about this, but court or labor commission cannot support him because they could not find any evidence. So I think I strongly suggest all workers should think again when they submit resignation letter. Also, if there is conditional resignation, then they must have a separation agreement. So without that, their legal right cannot be protected in Korean Labor Commission. Yeah.
I see. Thank you very much for introducing two different cases. But this in case the employer, employee signs the resignation letter based on the agreement with the employer that they will guarantee some retirement pension, whatever. But if he can prove that the employer was wrong and he lied, would there be other punishment in addition to the remedy claim from the labor office?
Yeah, I think just without written agreement, also even verbal recording, maybe it can be partly accepted as evidence, but not strong as like a written letter. So not strong as much as a written letter. So I think without mutual settlement agreement, I think submitting resignation is giving up his right. So we can see many examples. In order to receive one letter of resignation, many financial companies, they pay 2 years additional salary, also 1 year's additional salary, just because they want to receive a letter of resignation. Also, in the course of dismissing collectively for managerial reason, so usually as an effort to avoid dismissal, they promise to the target employee will pay ERP bonus, then please sign this termination letter. So in this case, they usually make the settlement agreement for termination. So this is very required. So don't submit your resignation letter. Just if it is something you cannot accept, please make some settlement agreement or mutual agreement. This way you can protect your legal right. Yeah.
I see. So based on your statement, I think it's very important for the employee to consider very carefully and also get the settlement agreement with the employer before they can sign any resignation letter.
Yeah, I fully agree with you. Yeah.
Okay, thank you very much.
Okay, thank you. Bye bye.